Hello everyone, welcome back to the channel EduTap. I am Arshdeep Kaur and today we start with the Companies Act 2013. So out of all the company laws, this is the most important topic of your syllabus. So please make sure that you go through it very thoroughly. We will be dealing with all the important questions that can be asked in the examination. So please make sure that you go through these videos. Alright, let's begin. Before I start, I would like to tell you that EduTap has come up with two courses for your phase 2 examination. The first one being the test series. The test series is very helpful for your practice and your revision. In this, you get chapter wise tests. So for each and every chapter, you have been given a separate test. For example, in IPC, in CRPC, there are different chapters and for each such chapter, you get different tests. Another feature of the test series is the full-length tests with evaluations. So since the descriptive portion has been added by SEBI for the first time, so for that evaluation for your answers is must. That is why our experts, they are going to check your answers and they are going to give you necessary feedback and let you know about the scope of improvement, right? So you get full-length tests that you can practice, and since now the exam is very near, you can start with these practice papers, right? So full-length test with evaluation, and you also get one-on-one mentor support. Apart from this, we also have a live crash course. The classes, they are already going on, and the classes which have already been conducted, you get the recorded sessions of those. So even now you can buy this course for your preparation. Then short notes will be given to you, so you can use these short notes to prepare your descriptive portion, and the same will be checked from our experts, right? And all the features of the test series, they are included in this live crash course also, so please make sure that you avail it. And also you get one-on-one mentor support, so your queries and doubts all will be clarified by the mentors. We are running a limited time period offer, so if you want, you can avail this offer by referring to the link in the description below. Alright, now let's start with our questions. Question number 1. The definition for nominal capital is given under section 2 clause 8, authorized capital or nominal capital. So nominal capital, it is also termed as authorized capital, means such capital as is authorized by the memorandum of the company to be the maximum amount of share capital of the company. What is nominal capital or authorized capital? So basically, to run a company, you need capital, and that capital is not with one person. So a company issues shares, right? So nominal capital is the maximum amount of capital for which shares can be issued to the shareholders, right? It is the maximum amount that has been fixed by the memorandum of company. So this is the capital which the company limits itself that it cannot issue more than this amount of shares to the shareholders, right? And it is mentioned in the memorandum of the company, right? So authorized or nominal capital means such capital as is authorized by the memorandum of the company to be the maximum amount of share capital of the company, and this amount, it can be changed by the approval of the shareholders, right? So this is authorized or nominal capital. Question number 2. What is the financial year for newly incorporated company? The answer is B. If company is incorporated on or after the 1st of January of a year, financial year shall be the period ending on the 31st day of March of the following year. Let's read this. This is 241 financial year in relation to any company or a body corporate means the period ending on 31st day of March every year. So it is 31st March of every year, and where it has been incorporated on or after 1st day of January of a year, the period ending on the 31st day of March of the following year in respect thereof the financial statement of the company or a corporate is made up. So basically for every company, it is 31st March of every year. But in case a new company has been formed and it has been formed on 1st of January or later than 1st of January, in that case, the first financial year is going to be 31st March of the following year, that is the next year, right? So this is question number 2, that is financial year. Moving on, question number 3. Which of the following is not considered as key managerial personnel in relation to a company? So the answer to this question is option D. A chartered accountant working in a company, he is not a key managerial personnel, right? So it is given in 251. Key managerial personnel KMP in relation to a company means the chief executive officer or the managing director or a manager, the company secretary, the whole-time director, the chief financial officer, such other officer not more than one level below the directors who is in whole-time employment designated as a key managerial personnel by the board, and such other officers as may be prescribed. Question number 4. What is the limit of maximum number of members in a private company as per the provisions of the Companies Act 2013? So as per membership, there are two types of companies, private and public, right? And one person company is also a private company. You have to understand this and remember this, that one person company is also a type of private company, right? So let's read this. The answer here is option D, that is 200. A private company means a company having a minimum paid up share capital as may be prescribed, and which by its articles restricts the right to transfer its shares, except in the case of one person company limits the number of its member to 200, right? So that is why I've told you that one person company is also a kind of private company, and except the one person company, every private company, the maximum members will be how many? The maximum numbers, it will be 200, right? It says restricts the right to transfer its shares. It says restricts the right to transfer and not prohibits. They restrict the right and not prohibit the right, right? So what does this mean? Restricts the right to transfer its shares. Let's take an example. There is a company, a private company. It already has 200 members. The members means here shareholders, right? So it has 200 members here. For example, one person, he has 2 shares, right? And he wants to transfer his shares, and he transfers each of that share to different individuals. That means now when he transferred his 2 shares to 2 different people, now the company's member became how many? They became 201. So that is why they have used this term that restricts the right to transfer its share, because the maximum limit of the members in a private company is 200. This right is not prohibited, but this is what? This is restricted. So restricts the right to transfer its shares, except in the case of one person company, limits the number of its members to 200. So there are maximum 200 members in a private company other than one person company. Provided that where 2 or more persons hold 1 or more shares in a company jointly, they shall, for the purpose of this clause, be treated as a single member. So if 2 or more than 2 people, they hold a share jointly, in that case all those members, all those people, they will be regarded as what? They will be regarded as one member only. Provided further that a person who are in the employment of the company and persons who, having been formerly in the employment of the company, were members of the company while in the employment and have continued to be the members after the employment ceased, shall not be included in the number of members. So the employees who are currently employed, if they are the members, and in case they have ceased to be employees but they still are members, they still hold shares, in that case also they will not be included in the number of these members, right? So they will not be regarded as the members for the purpose of counting those 200 numbers, right? So persons who are in the employment of the company, they are not regarded as members, and persons who, having been formerly in the employment of the company, were members of the company, they were in employment and they were members while in employment and have continued to be the members. Now they have ceased to be the employees but they are still members, shall not be included in the number of members. Prohibits any invitation to the public to subscribe for any securities for a company. So basically you cannot make a public offer to issue your shares in a private company, right? So a private company has been prohibited from doing so. So prohibits any invitation to the public to subscribe for any securities to the public. Alright, moving on, question number 5. What is the status of one person company according to the Companies Act 2013? B, it is a private company. This I have already told you that it is what? It is a private company. A company may be formed for any lawful purpose by 7 or more persons where the company to be formed is to be a public company. So for a public company, at least 7 members are required, that is 7 shareholders. 7 or more persons where the company to be formed is to be a public company. 2 or more persons where the company to be formed is to be a private company. So minimum number of members in a private company is 2 and maximum is how much? It is 200, right? So 2 or more persons where the company to be formed is to be a private company, or 1 person where the company to be formed is is to be one-person company, that is to say a private company, right? So here it is mentioned that one-person company is what? A private company. By subscribing their names or his name to the memorandum and complying with the requirements of the Act in respect of the registration, provided that the memorandum of one-person company shall indicate the name of the other person with his prior written consent in the prescribed form, who shall, in the event of the subscriber's death — subscribers are the initial shareholders that have subscribed to the memorandum of the company, right? So in the event of the subscriber's death or his incapacity to contract, become the member of the company, and the written consent of such person shall also be filed with the registrar at the time of incorporation of the one-person company along with its memorandum and article, provided also that the members of the one-person company may at any time change the name of such other person by giving notice in such manner as may be prescribed, provided also that it shall be the duty of the members of the one-person company to intimate the company the change, if any, in the name of the other person nominated by him by indicating in the memorandum or otherwise within such time and in such manner as may be prescribed, and the company shall intimate the registrar any such change within such time and manner as may be prescribed. So basically this is the procedure that has been given for the one-person company. Provided also that any such change in the name of the person shall not be deemed to be alteration in the memorandum. A company formed under subsection 1 may either be a company limited by shares, a company limited by guarantee, or an unlimited company, right? So I hope you are clear with question number 5. Moving on, question number 6. Consider the following statements about the articles of a company. The articles of a company shall contain the regulations of management of the company. A company shall not include any matter in its articles other than provided in Companies Act 2013. The articles may contain provisions for entrenchment to the effect that specified provisions of the articles may be altered only if the conditions or procedures as that are more restrictive than those applicable in the case of a special resolution are met or complied with. Which of the above statements are correct? So the answer to this is C, that is only first and the third statement is correct. But a company shall not include, this is wrong. A company can include any matter in the articles other than provided in the Companies Act 2013, right? So first of all, what are articles, right? What is article of association? Article of association is basically a document of the company that includes the rules and regulations of the company, that how that company is going to be run, how the management and internal affairs of that company are going to be operated, right? So it is how it is to be done. So it includes the rules and regulations of the company regarding the internal affairs and management of the company. For example, how the directors are going to be appointed or how they will be terminated. So all such matters, they are included where? They are included in the article of association, right? So basically all the rules, all the regulations that govern the company, they are included in what? They are included in the articles, that is article of association. Now let's read this section number 5. The articles of the company shall contain the regulations for the management of the company. So everything related to the management, it is going to be mentioned in the articles. The articles shall also contain such manner as may be prescribed, provided that nothing prescribed in this subsection shall be deemed to prevent a company from including such additional matters in its articles as may be considered necessary for its management. The articles may contain provisions of entrenchment to the effect that specified provisions of the articles may be altered only if the conditions or the procedures as that are not restrictive than those applicable in the case of the special resolution are met or complied with. So basically what is entrenchment? Entrenchment means to make something difficult to change. So if a company, it wants to make a clause difficult to change. For example, they want to make a rule that something, this cannot be changed by special resolution, it has to be changed by, for example, 90% of the votes. In that case, they can do what? They can include this entrenchment clause to that provision, right? So this is what the third one is saying. The articles may contain provisions for the entrenchment to the effect that specified provisions of the articles may be altered only if conditions or procedures as that are more restrictive than those applicable in the case of the special resolution are met or complied with. The provisions for entrenchment referred to in subsection 3 shall only be made either on the formation of the company, it can only be made either on the formation or by an amendment in the articles agreed by all the members of the company in the case of the private company and by the special resolution in case of a public company. where the articles contain provisions for entrenchment, whether made on formation or by amendment, the company shall give notice to the registrar of such provisions in such form and manner as may be prescribed. The articles of the company shall be in restrictive form specified in table F, G, H, I and J of Schedule 1 as may be applicable to such company. A company may adopt all or any of the regulations contained in the model articles applicable to such company. In case of any company which is registered after the commencement of the Act, insofar as registered articles of such company do not exclude or modify the regulations contained in the model articles applicable to such company, those regulations shall, so far as applicable, be the regulations of the company in the same manner and to the same extent as if they were contained in the duly registered articles of the company. And lastly, nothing in this section shall apply to the articles of a company registered under any previous company law unless amended under this Act. So, I hope you are clear with what is Article of Association. This is a very important document for the formation of company, right? Moving on. Question number 7. Consider the following statements. The name stated in the memorandum shall not be identical with, but it may resemble too nearly to the name of the existing company registered under this Act or any previous company law act. The name stated in the memorandum shall not be such that its use by the company will constitute an offence under any law for the time being in force. The name stated in the memorandum shall not be such that its use by the company is undesirable in the opinion of the central government. Choose the correct option using the code below. So, the answer to this question is option C, that second and third options are correct, but the first one is not, right? So, what is memorandum of the company? What is memorandum of association? Memorandum of association is basically the most principal document in the formation of the company. It is the most important document of the company. It is also known as the charter of the company. It is also known as the constitution of the company. In the same manner as you cannot go beyond the Constitution of India while making any other law, in the same manner you cannot go outside the scope of this memorandum of association for a company, right? So, basically it includes the powers, the objectives, the scope of the company. It is in fact the foundation on which the company is based, on which the structure of the company is formed, right? So, this is the most important document of a company. This is known as memorandum of association. It includes all the powers, all the objectives of the company, that why this company is formed, what are the powers the company has, what is the scope, what is the extent of this company. So, all such matters, they are included in the document, and that document is termed as what? It is termed as memorandum of association. So, now the name stated in the memorandum shall not. So, because a company is a distinct legal entity, it requires a name. So, that is why it is written that that name, it cannot be identical with, or it cannot resemble too nearly to the name of an existing company registered under this Act or any previous law, or be such that its use by the company will constitute an offence under any law for the time being in force. So, you cannot use an offensive name, or is undesirable in the opinion of the central government, or it is undesirable. The central government thinks that that name is undesirable. In that case, you cannot use such names for your company, right? Moving on, question number 8. If a company desires to get registered with a name which contains a word which gives an impression that the company is connected with any local authority, then previous approval of which of the following is necessary? The answer is option D, that is the central government. Without prejudice to the provisions of subsection 2, a company shall not be registered with a name which contains any word or expression which is likely to give the impression that the company is in any way connected with, or having the patronage means financial support, of the central government, any state government or any local authority, corporation or body constituted by the central or the state government under any law for the time being in force. So, basically you cannot use any such name which gives the impression that you are in any way connected to any such authority, for example the central government or the state government. Some examples for such names can be using the word central, using the word bureau, using the word national. So, you cannot use such names, right? Such word or expression as may be prescribed unless the previous approval of the central government has been obtained for the use of any such word or expression. But if you have obtained the central government's approval, in that case that name can be used, right? So, this was question number 8. Moving on, question number 9. Any provisions contained in the memorandum, article, agreement or resolution shall, to the extent to which it is to the provisions of this act be? The answer is B, that is void. So basically you cannot go outside the scope of the Companies Act, right? So act to override memorandum articles, etc. So this act, the Companies Act 2013, it has an overriding effect on the articles, the memorandums, any agreement that has been formed, that has been made by the company. Save as otherwise expressly provided in the act, the provisions of this act shall have effect notwithstanding anything to the contrary contained in the memorandum or articles of a company, or in any agreement executed by it, or in any resolution passed by the company in the journal meeting or by its board of directors, whether the same be registered, executed, or passed as the case may be before or after the commencement of this act. And any provision that is contained in the memorandum, articles, agreement, or resolution shall to the extent to which it is repugnant to the provisions of this act become or be void as the case may be. Right? So the part that goes inconsistent, that is inconsistent with the act, with the Companies Act 2013, that is going to be declared what? That will be declared as what? That will be declared as void. Question number 11. A company within how many days of its incorporation must have a registered office? The answer is option A, that is 30 days. So registered office of a company shall within 30 days of its incorporation, so after the incorporation within 30 days and at all times thereafter, have a registered office capable of receiving and acknowledging all the communications and notices as may be addressed to it. Question number 12. A company shall send the copy of the memorandum and articles to the members who requested the same within how many days? The answer is option C, that is within 7 days. So a company shall, on being so requested, when a member has requested to receive such article or memorandum, so it will be sent to him within 7 days, right? A company shall, on being so requested by a member, send to him within 7 days of his request and subject to the payment of such fees as may be prescribed, a copy of each of the following documents, namely memorandum, article, every agreement and every resolution referred to in subsection 1 of section 117, if and in so far as they have not been embedded in the memorandum or article. So any agreement or resolution that has not been mentioned in the article or the memorandum, that is also going to be given. If a company makes any default in complying with the provisions of this section, the company and every officer of the company who is in default shall be liable for each default to a penalty of 1000 rupees for each day during which such default continues, or 1 lakh rupees, whichever is less. So in case of default, a penalty of 1000 rupees will be levied for each day and a maximum can be 1 lakh rupees, but whichever will be less, that amount is going to be considered, right? Moving on, question number 13. A company incorporated after the commencement of the Companies Amendment Act 2019 and having a share capital shall not commence any business or exercise any borrowing powers unless a declaration is filed by the director within what period of the date of the incorporation of the company? So the answer is E, that is 180 days. A company incorporated after the commencement of the Companies Amendment Act 2019 and having a share capital shall not commence any business or exercise any borrowing powers unless a declaration is filed by the director within a period of 180 days. So it has to be filed within 180 days of the date of the incorporation of the company in such form and verified in such manner as may be prescribed with the registrar that every subscriber to the memorandum has paid the value of the shares agreed to be taken by him on the day of making such declaration. So basically, what is the declaration? That declaration will be that all the subscribers to the memorandum, they have paid the value of the shares that they have agreed to take, right? And the second one will be the company has filed with the registrar a verification of its registered office as provided in subsection 2 of section 12. If any default is made in complying with the requirements of this section, the company shall be liable to a penalty of 50,000 rupees. It is 50,000 rupees, and every officer who is in default shall be liable to a penalty of 1,000 rupees for each day during which such default continues but not exceeding an amount of 1 lakh rupees. Where no declaration has been filed with the registrar under clause A of subsection 1 within a period of 180 days of the date of the incorporation of the company, and registrar has a reasonable cause to believe that the company is not carrying on any business or operation, he may, without prejudice to the provisions of subsection 2, initiate actions for the removal of the name of the company from the register of the companies under chapter 18. So here basically a presumption arises if you have not filed that declaration within that 180 days, in that case it will be presumed that the company is out of business, right? So where no declaration has been filed with the registrar under clause A of subsection 1 with a period of 180 days of the day of incorporation of the company, and the registrar has a reasonable cause to believe that the company is not carrying on any business or operations, he may, without prejudice to the provisions of subsection 2, initiate any action for the removal of the name of the company from the register of the companies. Alright, moving on, question number 14. License to be registered as a company with charitable object is issued by which of the following according to the provisions of section 8 of the Companies Act 2013? So the answer to this is B, that is the central government. So basically a company formed under section 8 is basically a charitable company, right? Its purpose is to give its profits, its dividends not to the members but use for the charity, that for the very object that it has mentioned in its memorandum, right? So this is where it is proved to the satisfaction of the central government that a person or an association of persons proposed to be registered under this act as a limited company has in its objects the promotion of, so they want to promote this. The very object of the company is the promotion of commerce, art, science, sports, education, research, social welfare, religion, charity, protection of environment or any such other object. Intends to apply its profits, if any, or other income in promoting its objectives. So basically this company, it wants to use its profits in the promotion of this object. Intends to prohibit the payment of any dividend to its members, so they are not going to pay the dividends to their members, right? So intends to prohibit the payment of any dividend to the members. Then in that case, if the central government is satisfied, the central government may by license issue in such manner as may be prescribed and on such condition as it deem fit, allow the person or association of persons to be registered as a limited company under this section without the addition to its name of the word limited, or as the case may be the word private limited. So in that case the use of the word limited or private limited is not required. So if a company has been formed under section 8 of the Companies Act, in that case that company needs not to use these terms that are private limited or limited. And thereupon the registrar shall, on application in the prescribed form, register such person or association of persons as company under this section. Alright, last question, question number 15. Dash is an instrument through which Indian company can issue its shareholders across the globe. So the answer is B, that is Global Depository Receipt. Section 41. A company may, after passing a special resolution in its general meeting, issue depository receipts in any foreign company, in any foreign country in such manner and subject to such conditions as may be prescribed. So basically a global depository receipt or a GDR is basically a negotiable instrument that is issued abroad by an Indian company to raise funds in that country, in that foreign country. And also it is listed in the foreign exchange of that country, right? So this is GDR, and the holder of the GDR can convert it into the number of shares it represents, right? So basically this is an instrument, it is a negotiable instrument, right? So this is GDR, that has been provided under section 41. Alright, now question for achievers. Section 23 of Companies Act 2013 deal with the ways a public company can issue its securities, namely to public through prospectus, private placement, by bonus issue, by right issue, or all of the above. So you have to mention the right answer below. Alright, that was all for today. I hope it was a helpful session for you. For more such videos, please like, share and subscribe to the channel EduTap. Thank you.